I feel muted dem alle sammen.
Great. Well, good morning, good afternoon, and good evening to you wherever you are in the world. And you're very, very welcome to another great event from the European Maritime Law Organization. And you're very welcome on International Women's Day to a great event which is being presented to you by two great women of the maritime world. My name is Vincent Power. I'm the current chair of the European Maritime Law Organization, and it's my pleasure to introduce the topic and the speakers and very much leave it to them, particularly given the day that's in it. The topic is taxonomy. Taxonomy and its effect on ship owners, ship finance, marine insurers, and charters. And I have to say that when I first heard a few years ago about taxonomy, I thought it had something to do with the stuffing of dead animals. And I was a bit surprised why we were beginning to discuss the stuffing of dead animals. But when clients started to ask questions and pay fees, I knew it was serious. And it is a really important topic, and it's becoming more important, and it's still unclear, at least to me. So it's great that we have two experts, two great experts, to unpack and to unbundle it for us today. And so that's the topic, taxonomy. The speakers, they need no introduction, but being a lawyer and fearful that everything will go wrong, there'd be a very bad case of mistaken identity, I would, of course, give you introductions. But as I say, they need no introduction. Dr. Anna Bredima is a council member of the European Maritime Law Organization, a senior policy advisor in European affairs to the Cypriot Union of Shipowners, represents the Cypriot Union of Shipowners at the European Community Shipowners Association, is a lawyer at the Supreme Court of Greece, has an LLM from the University College London, has a PhD from the University of London, co-wrote the great book which, you know, opened the way for everybody else to write on this area a number of years ago. So with such a wonderful introduction, I feel we should take a break at that stage. It was a fantastic CV and a wonderful and brilliant lawyer and person to boot. So that's Anna Bredima, and Anna will interview Dr. Katalin Dobránszky, who is again equally amazing, an EMLO member and the ECSA Senior Director of Innovation, Finance and Fiscal Affairs. So based at the European Community Shipowners Association, Katalin, in her position, she focuses on ship finance and tries to raise the awareness of ship finance with the EU institutions and the EU regulators. And having worked in a wide range of issues for the last 2 decades, specializing in sustainable finance, she uses her experience and expertise at helping ship owners and stakeholders navigate sustainable finance, an issue which is of huge importance and only going to be of greater importance in the years to come. And Katalin is trained as a risk manager, an investment analyst, as well as trained in the law, and has studied in Budapest, Maastricht, and in Cambridge, and holds a PhD in sustainable finance, and is also a member of WISTA, the Women's International Shipping and Trading Association in Belgium. The format is very straightforward. Anna will interview Katalin, and that Q&A format should help bring a lot of issues out. In terms of housekeeping, we will go for 1 hour maximum to the top of the hour. We're mindful of everybody's lunch, etc. Anna, thank you for preparing such thorough and tough questions. And Katalin, thank you for subjecting yourself to Anna's interrogation. And as your self-appointed lawyer, may I say that you can plead the fifth every so often if you need to in terms of self-incrimination. And before I hand over to Anna in Athens and Katalin in Brussels, I want to thank Tess Bright from EMLO in Cyprus, Sarah Murray in Southampton, and to Johan Gerloff, who's joining us today for the first time from Garrison Federspiel in Copenhagen. They're the people who make all of this happen. And the technology, which has been so brilliantly provided by Garrison Federspiel, makes all of this work seamlessly. And while the webinar is being recorded, remember that by participating live, you're able to think of questions, and at the end of this session, at the end of the Q&A, you can pose your questions to Anna and to Katalin, and it's a great way of getting free advice from the very best in their field. So think of hard questions, enjoy the session, and it's over to you, Anna, and no pressure in terms of time.
Hello to you all. Vincent, thanks so much for your kind words. But beware of a webinar run by two women on the International Women's Day. Now, on the 21st of April 2021, the European Commission published the horizontal legislative package on sustainable finance for climate change purposes, alias the Taxonomy regulation. This covers also the maritime transport sector in compliance with the European Green Deal and the Paris Agreement on climate change. Taxonomy comes from the Greek word taxinomia, meaning the science of classification. Environmental taxonomy will put in place a whole spate of technical requirements on shipping activities to qualify as green activities in order to inform potential investors. This webinar will give you a summary of legislative developments as well as challenges and opportunities that the shipping industry, characterized as a transitional activity until 2025, is facing. Now, this is the second EMLO webinar on taxonomy after the one on the 7th of July 2021. We anticipated then that many more webinars would be required to demystify taxonomy. Indeed, a lot of questions have arisen since, and delays were registered in adopting practical hands-on definitions. Now, Dr. Katalin Dobránszky, with her dual qualifications and expertise in law and finance, will guide us through the legal maze of taxonomy. Katalin, what regulatory acts have been adopted so far? We are at a crossroads where, despite the delays, the implementation of taxonomy has started, and the legal interpretation of the technical rules puzzles everyone. Do you see it as an opportunity for the shipping industry to come up with practical solutions?
First of all, thank you very much, Anna, for this very kind introduction, and also for Vincent and for the whole team and EMLO for giving me this opportunity to talk about taxonomy. Let me first say to you that taxonomy has always been my baby in a way. I have been dealing with this issue since its birth from 2018, and it's a very complex issue indeed. And no matter how many webinars we are going to organize, questions will flood in because of the complexity and the layers and the developments, of course, of this file. Getting back to your first question, Anna, on what are the regulatory acts? Here you see a slide which kind of summarizes in brief what is the taxonomy framework. And let me just very quickly guide you through this slide. So the underlying regulation that provides the framework has been published in 2020. This is the so-called taxonomy regulation. This is a directly applicable regulatory law to all member states of the European Union. And this taxonomy regulation provides the mandate for the Commission to also use so-called delegated regulatory pieces, delegated acts, which are specifying and defining furthermore in details whatever is the framework is requesting. What the big difference is between this regulation and the delegated act, and most of you know very well, is that the delegated act as such, it doesn't need a full regulative process in the EU. On the other hand, being a technical discussion and being very detailed, close to very technical, minor, small details, of course, we also know that the devil always hides in the details. So we have to be careful what in the end is the end result of this delegated act. The first delegated act is the so-called Article 8 delegated act. This is defining what exactly is the taxonomy for. It's a reporting requirement. The EU taxonomy has been defined to report and to disclose certain information that how big proportion of a company's or a financial provider's portfolio is taxonomy eligible and taxonomy aligned. And yes, again, there are two terminology now which might be very confusing. Taxonomy eligibility means that any kind of economic activities that are falling under the scope of the taxonomy in the current form, all the NACE codes that are registered and mentioned in the taxonomy regulation and its delegated act will be considered as taxonomy eligible. In that sense, also the maritime and seagoing vessels and transport activity is going to fall under the eligibility criteria. So maritime transport as such is part of the taxonomy scope. Alignment means how much of those economic activities which are taxonomy eligible are going to be taxonomy aligned. In other words, how many of those are going to comply with all the criteria that is giving a definition of which activity is actually considered to be green. And then just to make it a little bit more digestible from a reporting perspective, this delegated act Article 8 is requesting that all these proportions of taxonomy eligible and aligned economic activities should be shown in terms of turnover in CapEx and OpEx of the companies. I think so far it sounds a little bit complicated, but I think when people start to think about what is exactly is the definition of an economic activity, especially under maritime, it's easier to understand. The economic activity itself is defined, as I mentioned, by the NACE codes. And in case of maritime transport, the underlying economic activity is actually asset-based, meaning that we are looking at which vessels are green. So that's basically what the taxonomy classification means in this case. Then there is another delegated act which is already in force. That's the Environmental Delegated Act number 1. This has been published last year, and it fully applies already from last year on. And basically, this is the one that is defining the technical screening criteria for the maritime only until up to 2025. Why am I saying that? Because the maritime industry is in transition, and also the regulator understood that. The long-term criteria for being a vessel being green would mean a zero tailpipe emission vessel, meaning no emissions at all. We know that technology-wise, this is at this stage, at least until 2025, is very, very unlikely that this is happening. So the regulator gave some additional criteria, which still means that the vessel can be considered green if they comply with this additional criteria, which are not zero tailpipe. And then it's listed in this delegated act. And then I will get back to you why it's important that it is only until 2025. Legally, it creates a challenge. Then finally, I mentioned on this slide the second Environmental Delegated Act. This is in the pipeline. This is, in principle, should be defining the technical screening criteria for after 2025 and also other environmental objectives. And just to make it clear what this is exactly about. The EU taxonomy has been defined or has been figured out to give a tool for the investors to define what economic activities are green, so they can easily say that, okay, if this is taxonomy aligned, me as an investor, I only want to invest in sustainable projects, then I can use this classification system. This was the whole purpose of the taxonomy. So they came up with a very complex definition for this. Number one, the taxonomy regulation is saying that any kind of economic activity, so in our case, it's the vessel, can only be defined as taxonomy aligned if it contributes substantially to at least one of the 6 environmental criteria that is listed by the regulation. Plus, it complies with all the do no significant harm criteria, meaning that it gives a significant substantial contribution to one or more environmental criteria, but it doesn't give any worst situation for the other environmental objectives. And finally, and this is very important, all this happen, and then you have a super green vessel and you comply with it, but your company doesn't comply with the ILO and the OECD conventions on human rights and labor law, then you cannot be considered to be having green economic activities. So this is the 3 pillars of the green economic activity definition. I will leave it for the time being now here, and I would like to quickly answer the question of yours, Anna, on what are the challenges and the opportunities. And here I really would like to mention on an overall situation that the taxonomy is a challenge, but it also is an opportunity. And throughout the discussions, I hope that I will be able to give you a little bit of better understanding why I'm saying this. The taxonomy is actually going to be used, or is it already in use, for companies who are under the scope of the non-financial reporting directive. They are generally large companies who have to report on this taxonomy eligibility and alignment. This is the direct requirement of the regulation. However, we mustn't forget that all other companies, regardless of their size, regardless of their situation, will be asked in the European Union to provide the same data. Why? Because the banks, the financiers, the investors, they are required to provide this data. If the banks do not have the data from the companies, doesn't matter how small a shipping company is, they will not be able to provide the same data for their supervisors. So there is a direct, indirect impact also on smaller companies. This is a challenge, how to deal with all these resources, the complexity, and how to define these green economic activities. Furthermore, there are some content related matters. We all know, we have seen and we have been fighting from the beginning to consider one of the criteria under the Delegated Act to be reconsidered, to be reviewed, and this is namely the cargo restriction. Unfortunately, there was a political decision made that all transport sectors can only be considered green based on the taxonomy if they are not dedicated, if the transport asset, in our case the vessel, is not dedicated to transporting fossil fuel. What exactly this means, we don't know yet. There is also a level playing field in the understanding still, because the final interpretation hasn't been yet provided. But at the same time, it is a very restrictive criteria, especially given that from a ship owner's perspective, the ship owner, for buying a vessel and making it the most sustainable ever, shouldn't be penalized for something which is a matter of market supply and demand. This is something that we have been advocating for a long time. This is a challenge that stayed in the taxonomy. Further content related issues are also raising challenges and opportunities, such as I mentioned, the zero tailpipe emissions. As we know that the long-term criteria for zero tailpipe emissions, zero tailpipe vessels, is there, but I also mentioned that this is not possible in the short term. So what is the problem legally? The problem is that currently only the first delegated act is in force. The other one hasn't yet been finalized and published yet. It's not a legal act, meaning that if this second delegated act is not going to organize or answer these concerns, what happens after 2025, none of the transitional criteria applies, and this means that based on the taxonomy, only zero tailpipe emission vessels are going to be considered as green, which for the next decade at least is going to be pretty unlikely. So this is one of the biggest challenges that we see here. On the other hand, there is still criteria which has not yet been developed. And the regulators and also the stakeholders by now, they know it. The taxonomy is not a full handbook. It's not a ready handbook. It's in the making. It's a living document. It's a try and see situation from the regulator. So it also gives the opportunity for us as the shipping industry to see and try in practice what works, and to suggest new interpretations, new definitions. So in practice, I would say that the challenge is certainly to provide a stability regarding some regulatory classification, which was the initial purpose of the taxonomy. At the same time, because we are still in the transition phase in terms of the regulation itself as well, it's very easy to also formulate and see how things can work for the future. I hope that gave you a little bit of a nutshell explanation on what taxonomy was.
Now, Katalin, overall, the legislative process on taxonomy has revealed a lack of maritime expertise of policymakers. This ignorance of how shipping works hampers progress and may lead to errors and lack of practical solutions. This lack of shipping expertise was obvious in the sustainable finance platform established with the best of intentions to advise the European Commission, DG FISMA. Indeed, initially, there was not a single shipping expert in the 51 participants of the platform. Following pressure from the shipping sector at a later stage, an ad hoc shipping participant as observer was allowed. It was Katalin. On November 28, 2022, the platform submitted its report to the European Commission. We also understand that in September 2022, very well-known NGOs like the WWF and the Transport and Environment and others decided to leave the platform. They, quote, "will dedicate the resources to develop scientifically based taxonomy and explain to investors and financial services providers to refrain from the controversial elements of taxonomy," end of quote. What are the main reasons for leaving the platform? Their experience from participating in the platform did not enthuse them with its work. What is expected from the taxonomy process now?
Thank you, Anna, for this question. Of course, this has been a highly debated event in the past. But before I'm trying to answer your questions to my best knowledge, I would like to remind you that we mustn't forget where this whole project started from. And again, most of you probably have heard this from me, but it's very important to understand the background of this project. If you go back in time to 2018, which was not long after the Paris Agreement was signed also by the European Union, the then commissioner and the president of commission, Mr. Juncker, decided that there is time to do something about sustainability, and it was not part of the political agenda at that time. So it was just a time where the financial sector was heavily regulated. They kind of came back to their normal practices in banking after the crisis of 2007. So it seemed to be a good opportunity with a stable banking sector to give a pillar to this sustainability agenda. And what they came up with was a very ideological thought that if Europe is only financing green projects, then there will be only green projects in the end in Europe. We all know that this is not how it works in practice, but it started off the birth of the taxonomy, first in a communication format, and then suddenly the taxonomy, the now well-known sustainable finance platform's predecessor, was made. And there were a lot of investors, a lot of financial sector related experts invited to this platform because it was particularly a financial services initiative. However, and this is what was the initial aim, is to provide some tools, some informative tools for the investors. That was the main aim. But then we moved into a new era. A new commission came, and the sustainability and the Green Deal agenda became the high priority. And then they realized that there is not much yet on the table to start up delivering on the Green Deal priorities. So what happened? They took the one that was already somehow there, and this was the taxonomy. And because this taxonomy was highly prioritized due to a different political setting, please allow me to say that these stuffed animals just get out of their cage and started to grow into a beast on the market, which was completely misinterpreted, misunderstood, simply because the perception of the market was something different. But again, I need to remind you that a lot of years have passed on since, and then we learned the lessons, and then we had heavy discussions, and then we had a lot of on an ongoing convincing and education. And then we reached a point where the sustainable finance platform needed to deal with a lot of technical details, something that the financial sector didn't have the expertise on. So what happened? Yes, Anna, you mentioned rightfully, it was a very difficult time because there was a lot of engineering related discussions on the criteria, whereas it should have been understandable for the investors, for anybody who is not an engineer, not myself. I'm not an engineer myself either. And it was very difficult even to ask the questions in this platform. So that's where they started to realize that sectoral experts are needed for very different topics to be discussed. This went all well, and I think we got onto a right track, and discussions were ongoing. And I have to say that even with the NGOs, we had very good relationship, we had very good discussions, and the outcome may not have been the best one, but at least there was a discussion and something to hang on and try. And then suddenly the NGOs decided to leave the platform. I don't have any background or expertise to judge or to say why they have left the platform, anything else that is publicly already known. But we need to remember that one of the key political questions and decision point for them was the recognition of the nuclear energy, whether it should be recognized, nuclear technology should be recognized as a taxonomy compliant technology or not. So this was one of the questions that was around this timing of NGOs leaving. One thing we surely can say, and this is something that we explicitly have also from the NGOs who admitted, maritime was not the reason they left the platform. And I think this is pretty reassuring, at least for this discussion. At the same time, we have a different process now. The platform has changed their mandate. Their previous platform's mandate is over, and there is a new platform with new members. The platform members, the permanent membership has been reduced significantly from 68 to 28 people. They are mostly, again, focusing on financial services experts and business experts, and also to some prioritized industrial sectors such as renewable energy and so on. And the main reason for it, because they realized on the one hand that they need a lot more experts than what the platform's membership would have allowed. So they now work more on an ad hoc expertise basis, inviting ad hoc experts into the discussions when a certain topic is raised. And secondly, they are trying to streamline the mandate of the current platform. As far as we understood, the next 2 years, the Commission is still debating what will be the priority of the platform, but one of the main issues is to look at the already existing regulatory criteria and to see how usable they are in practice, how to implement them in practice, and to work on the reporting templates. So make really the technical usability of the taxonomy more hands-on. I think that explains a little bit the current process.
Katalin, Daniel Guéguin, the renowned professor of Collège d'Europe, on the 24th of November 2020, tweeted on taxonomy as follows, quote, "The European Commission's sustainable finance taxonomy bears all the hallmarks of failed governance, opacity, imprecision, and subjectivity with a punitive approach, albeit not assumed. In short, it's an Orwellian mechanism," unquote. In the same vein, in the first EMLO webinar, I remarked that Greek mythology lends us a simulation of taxonomy, putting shipping on the Procrustean bed in order to fit it to its technical screening criteria. The role of Procrustes would be played by European regulators. Are these criticisms justified, or is there room for shipping to participate constructively and make the best out of the process?
Anna, these are the sensitive questions. Are these criticisms justified? Yes and no. In my opinion, first of all, again, please let me remind all of you that we have come a long way since Daniel also made this remark in 2020, I think. And yes, at that time, the taxonomy was really concerning, especially for the maritime industry. There were a lot of remarks and concerns from other industrial sectors, but from a maritime industry perspective, it was certainly concerning. What is important to understand that since then, a lot happened. And why we were in the first place very concerned about this taxonomy back in the time was because of the market perception, how the market perceived this taxonomy. So basically, despite the fact that the regulator had a very different aim with the taxonomy, as I mentioned, it was more for reporting and giving a tool to identify the best-in-class green activities for sustainable investments. The market started to pick it up more as a priority, as any kind of sustainable overarching definition. Whatever I'm doing is only sustainable if it's taxonomy aligned. And this is not correct. This was not the purpose of the regulation, but this is not how also the market wanted to understand. So what happened? We started to see that those industrial sectors who were not even considered to be spoken about under the platform as part of the taxonomy discussions were automatically considered to be the black industrial sectors. This is what we faced also as maritime. And we were very worried that maritime is not going to be part of the taxonomy discussions and the regulations. Since then, we have come a long way. The maritime has been recognized as a transitional sector, as a potential for sustainable activities. This is a very good part. But again, I need to highlight we are in a transitional period. And also the regulation itself is in a transitional period. It's a learning curve, it's a living document. So on the one hand, again, we are facing that we need certainty desperately, also for the financial providers, for investors, for ourselves to run our business. Because if we don't have that certainty, we have problems with getting funding. But on the other hand, we are still, as I said, in kind of a flexibility and a dynamic stage of defining what this exactly means. So it is indeed key to be part of the game. We cannot ignore it. We have to be part of the game in order not to get any harm. But I certainly think that we have come a long way since these criticisms have been formed, and we still have a long way to go.
Katalin, in light of concerns expressed as to the spillover effect of maritime taxonomy, what are, in your view, the implications at international level? Isn't it a dangerous precedent for the EU to devise regional standards for a global industry like shipping? Which are the implications on other jurisdictions like the Asian countries and the US? Are they going to follow EU rule makers and devise similar yet different screening criteria? We note in this respect that the EU co-chairs with China the International Platform on Sustainable Finance, and the US expressed concerns about the EU taxonomy.
Well, we all know that the maritime industry and the shipping industry is an international industry. We are linked to the international beams. So for us, international regulation is key. However, we also need to understand that the European Union decided to go down in a line to be the forerunner on sustainability regulation, and taxonomy is one of these examples. When it comes to international taxonomies, yes, there are international taxonomies. Actually, many jurisdictions copied the idea, not the whole regulation itself, but the idea of such a classification system for information providing. Some of them actually have the creativity to improve it, seeing the mistakes and the problems and the criticism of the European taxonomy. Some other jurisdictions see it as a potential competitiveness tool for protecting their own industries, but certainly we see some type of a fragmentation. On the other hand, again, I need to go back to my previous remark that we mustn't forget that it's still a living document. It's still on a learning curve. So until we are in this phase and we don't reach the final handbook, the final outcome of this requirement of this definition handbook, we can expect that there will be fragmented solutions and different solutions for the same aim. Again, it is very important to understand that the taxonomy cannot do any harm for the shipping industry in funding if the market perception is in the correct place. So we need to make sure that the European characteristics are properly recognized in Europe and the taxonomy is handling the shipping industry's needs.
Katalin, taxonomy definitions regarding eligible activities should take into account the diversity of maritime activities, where a one-size-fits-all approach is a recipe for disaster. There is diversity of activities and segments: liner, tramp, deep sea, short sea, offshore, service vessels, diversity of ship sizes, ship types, and business models, existing ships and new ships. What guidance would you give to policymakers as a rule of thumb?
I think, Anna, you already gave the guidance in your remarks on that one, but certainly our guidance without any hesitation would be to warn the regulators and any stakeholders. It's not only the regulators, but including those stakeholders who have to implement these regulations. For example, the finance providers, that a one-size-fits-all does not work. For the reasons that you mentioned, that we indeed cover, maritime covers a lot of different vessel types in terms of size, in terms of type, in technology. We cover short sea and deep sea. We cover different business models. We cover different size of the companies. So this all matters when it comes down to how we try to inform the investors about the sustainability projects. So this is certainly a message we have been very clearly pushing through or trying to send through towards the regulators. One thing though that I again would like to highlight, that the current setting, the Delegated Act 1, the Environmental 1 Delegated Act, it gives also the definition, what is the definition of deep sea transport activity, for example, seagoing transport activity. And it covers the entire spectrum of different vessels. So we do believe that there is the potential to actually increase the diversity of the regulation to make sure that we cover without a one-size-fits-all rule. But again, this was started somewhere, and the currently existing criteria may or may not be good for some and for others. But this doesn't mean that in the future this cannot be further developed, of course, with the caveat that there are still some concerns regarding technology requirements.
Katalin, could you inform us about the reasons for exclusion of the cruise lines from taxonomy? We understand that the speed limit related operational criteria were not identified in the platform as being the right technical requirements. Moreover, speed reduction is not anymore an IMO short-term measure to decarbonization. Is it confirmed that speed limits and underwater noise due to lack of relevant information will be excluded from the taxonomy process until further notice? Which are the prospects regarding these issues?
Okay, what I mentioned in the beginning on this slide to explain what kind of legal acts are in place. We were talking about the first environmental delegated act. This handled only climate change mitigation as an environmental objective for the maritime industry. What Anna now mentioned, this is bringing in aspects of another environmental objective with other technical screening criteria and other definitions. And this is linked to the pollution prevention criteria, the pollution prevention objective. The pollution prevention objective for maritime, for seagoing vessels is also very complex. It brings in a lot of different topics from greenhouse gas emissions to underwater noise and to water protection and so on. There are very different issues linked to this. And in the old mandate, the previous platform's mandate was to actually work on this criteria, on this set of criteria for pollution prevention and provide an additional definition for seagoing vessels. However, they came up to the level where they gave a first proposal. This proposal was heavily criticized by the entire industry and all related stakeholders, because it was not feasible from the banking side. It was not feasible to live with it, and there were technically wrong solutions in this technical screening criteria. And one of the key concerns that we had at the time is operational criteria. This is purely from an investor's perspective is very hard to assess. If you think about the fact that you want to buy a vessel and you need funding upfront, then the bank needs to assess the risks. And then the bank has to make you sign a proof that you are going to make sure that you are never going to speed over a certain limit. This is not going to happen. It's something that you as a ship owner cannot offer. You cannot prove it. So it was a practically not working solution. Plus, given that the definition of the taxonomy is vessel-based, it's asset-based, how is it? It was simply not possible to see operational criteria into this pollution prevention. In the meantime, as you mentioned, Anna, things are also moving at IMO level. Unfortunately, this pollution prevention has not been any further discussed. So our expectation that for the time being, this is not going to be covered. And we are hoping that as soon as it pops up again, it will be rediscussed from zero again, because this needs very heavy discussions in detail.
Katalin, the taxonomy process came into being with the best of intentions to facilitate the decarbonization process. Is it going to facilitate or complicate EU ship owners' lives by reducing finance opportunities? Is taxonomy going to drive to more consolidation in the market? What would be the implications of cumbersome administrative reporting formalities for small and medium-sized enterprises? Are they going to be driven out of the market for lack of sustainable financing?
Anna, I wish I had the glass ball to tell you what brings this for the future. when you asked me actually 2 years ago about the same question, I was very concerned, and probably I would have said all the negative answers to your question. Now you're asking me again, I'm more positive because since then things have changed. And one of the key issues that we need to know, there is a lot of willingness on the finance market to actually finance sustainable products. Yes, the taxonomy has some implications on how these sustainable products are going to be perceived. But again, I need to go back to the warning that luckily at that time, when the taxonomy get out of its cage and we were really losing control over the taxonomy, how it is used, now with all this education, with all the discussions ongoing from our part as in the industry, we see that the taxonomy somehow is trying to get back to its own cage and serve the purpose it was designed for. As far as we can make sure that the taxonomy is understood in its correct interpretation, until then, I think that there is a chance that it's not going to be purely the taxonomy harming the companies or their possibilities to get sustainable finance. It is also important to note that SMEs also are more exposed to some of the risks that it bears, simply because of the resources, because of the complexity of this matter. But on the other hand, the stakeholders, the financiers, the regulators, the supervisors, the industry itself is working heavily on solutions to reduce this burden, especially on the small and medium-sized companies as well. So as far as taxonomy stays a reporting requirement, I think it can be kept in its cage.
Katalin, the sustainability reporting standards, environment, social and governance, ESG, are gaining ground worldwide in the financing of the shipping sector and of other industries. These standards are in the making and they are linked to taxonomy. Whilst the Poseidon principles may be helpful to facilitate decarbonization, what is really needed is to avoid proliferation of arbitrary criteria and the lack of uniformity leading to a patchwork of rules. Regulation coming out of IMO is necessary, not private sector-driven criteria. The basic position of the shipping industry is that non-regulatory classification tools under sustainable finance are unwelcome for being arbitrary and not unified. What hurdles do you anticipate in this process?
We certainly do anticipate challenges in this process, purely because, as I already mentioned to you before, this is still a document, still a regulation in the making, and it will be for the next few years, surely, long few years, surely. And until we reach a place where we can say that there is a reason for regulatory harmonization, stability in this regulatory file, there is a gap in the market to cover certain segments that are not yet covered, different interpretations, different aims even for information providing of investors. And until this is the case, we expect that these gaps will make the place for parallel initiatives, for private initiatives, for new initiatives. On the one hand, I have to say that we as ECSA, we very much advocate for regulatory requirements, only because we also know that financing and also the business stability is key. We need the stability, we need the certainty from the regulator. But again, one of the key challenges will be